I'd like to welcome you all to today's webinar. Today we'll be discussing workplace investigations and in particular the top 5 mistakes that can happen during a workplace investigation. We'll also discuss how we can avoid those mistakes during the investigation process. The idea today was for me to be joined by our Associate Director, Julian Arndt. Unfortunately, Julian is unwell today, and so as his replacement, we have our Director, Cahill Scott. Cahill is our Director in the Newcastle office, and he's joining us via webcast from Newcastle today. It's really great to have Cahill stand in, especially at late notice, because Cahill has a lot of great insights when it comes to investigations. Cahill, if you'd like to introduce yourself.
I can, Sam. Thanks for that. And sorry, everyone, for the false start. We're obviously in different locations today. Happy to be the last-minute substitution for Julian Arndt, who I hear might have partied a little bit too hard at the Industrial Relations Society annual conference over the weekend. And so he did fill in for me, Sam, a few months ago when I was ill. And so it's good to be able to return the favour for Julian today.
Oh, good to hear. Very good. We've got some great content for everyone today. We want to make it as engaging as possible, so it will be a little bit informal. We're going to be getting Cahill's take on the various topics that come up. We'll also be doing our best to answer any questions that come through. And we have read the questions that have already come through in the previous days, and we're doing our best in this presentation to cover off on some of those key issues that often pop up when you mention workplace investigations. So without further ado, here is our list of the top 5 mistakes that people make during the investigation process. So I'm going to give a quick overview of these top 5 mistakes before we get into the detail. The first one there is about finding the balance of what to investigate. We certainly cannot investigate every grievance. That would be absurd, but we certainly cannot investigate nothing. We cannot sit back and leave certain complaints just go unattended. So the mistake there is failing to investigate or investigating too much, and we're going to talk about finding that balance between those two extremes. The next one is about choosing the wrong investigator. We've got some good tips on who you should be choosing to do your investigation and why you should be choosing that person. The third one there, we're calling it the golden rule. You might know it as procedural fairness. We're going to be talking about the need to put allegations with sufficient particulars to a respondent and to give the respondent a reasonable opportunity to respond to those allegations. It may sound familiar. We'll be talking about some of the the scenarios that pop up when we go through that process and how you might be able to manage those scenarios. Second to last is a report without reasons. So another common mistake, it is incumbent on the investigator to write a report that not only sets out the findings of the investigation, but also gives reasons. It actually explains how the investigator reached those findings. We'll talk about that. And the last topic is this concept of muddying or murkying the distinction between the role of the investigator and the role of the decision maker. And when we say decision maker, we're talking about the person who decides what, if any, disciplinary action will be taken on the basis of the report. So let's get stuck into it. The first topic here as a mistake is to investigate everything or nothing. Ideally, we want to end up somewhere in between those two. And we've got these points about when to investigate. So the first, and I guess a fundamental or even a philosophical question is, what is the point of an investigation? Why do we do it? I know Cahill has some strong views on this point. I'll throw it open to Cahill.
Thanks, Sam. Look, ultimately, I think what's the point of an investigation is a pretty easy question to answer. What you're doing when you're investigating is you're simply trying to find out what's occurred. So you're gathering the facts or you're gathering the information. So you're kind of putting your detective hat on and trying to work out what's happened. But if we take a step back, you're right, Sam. Sometimes you see businesses or clients investigating absolutely everything under the sun and having quite a formal investigation process for just about every grievance that's raised. And then at the other end of the spectrum, you see people who should be investigating certain things that aren't kind of following a rigorous enough process. And so the first point I'll make is, as an employer, your response to a particular concern that's raised should be proportionate to the seriousness of the concern. So to give you an example, you might have an employee who says, one of my colleagues, person X, spoke to me yesterday and they spoke to me rudely, or they were dismissive, or they didn't listen to my point of view. That might be a typical grievance that might be raised with a line manager. Now, my view is you don't need to start a formal investigation about that and have meetings and letters back and forth and have an investigation report, because the complaint just doesn't warrant that level of formality and that level of detail. The complaint is more in the nature of, providing some feedback about something happening that the person's upset about, and the appropriate manager perhaps going and having a chat to that person and saying, look, something's come to my attention about the way that you're interacting or the way that you're speaking to people. Can you just be mindful of that some people might be sensitive, or, can you've had issues in the past with the way that you communicate with your colleagues. And it's effectively what I would call a counselling session or an informal chat with a particular employee that should be file noted. So it should be some form of written record of the fact that that's occurred. And that may be sufficient. And now that person might acknowledge that they were in a bad mood and spoke rudely, or they might say, absolutely not, I don't know what you're talking about. So that's a scenario where there might be a fact in issue or a fact in dispute where the person effectively denies the allegation. But what I'd say is it going to be a sackable offence? If it's not, it might not even be a written warning type offence, then you probably don't need to go through this huge formal process to discover whether or not the person spoke rudely, to then potentially give a written warning or maybe give a verbal warning. Like, it just doesn't warrant that level of detail. So I think your response should be proportionate. Sam, you're right. You don't need to investigate absolutely everything, but equally there are things that are serious. And, certainly if something might warrant termination, or if there's an allegation of bullying or sexual harassment or misconduct or something unlawful, then I think that kind of informal chat's not going to be enough. So you just have to balance your response based on how serious or not the concern is. Yeah, and so the other thing I'd say, Sam, and then I'll hand back to you, is when to investigate is a kind of interesting and vexed question, because there's no universal obligation in Australian law that tells us, like, there's no Workplace Investigation Act in Australia that tells us in clear terms when we need to investigate and when we don't. So there's no single legal kind of framework that we have to look at. But what we do have is this patchwork quilt of laws, of workplace laws, that indirectly require us to do certain things or to deal with things in a particular way. So, for example, if someone's employment's terminated and they bring an unfair dismissal claim challenging the fairness of the dismissal, whether or not the employer has looked into it and properly investigated is obviously going to be relevant. Under work health safety laws, if there's serious complaints being made and you're not doing anything about it, then you're potentially in breach of your obligation to provide a safe workplace. Equally, you've got workers' compensation laws, you've got bullying and sexual harassment laws, you've potentially got breach of contract type laws. So there's all these laws out there that you need to kind of be familiar with, because ultimately, if something is raised and you don't do anything, or you don't sufficiently look at it, then you may fall foul of some of those other laws, or it might, or you deal with it in a way that's not reasonable, that might, warrant a workers' compensation claim, for example. So the legal framework is a little bit messy, but the best guidance we can give is your response needs to be proportionate.
I agree, Kyle. And just in terms of that legal framework, it is something that's always evolving. So in recent months, we've seen the introduction of a positive duty to prevent sexual harassment or eliminate sexual harassment in the workplace. And so against this sort of ever-evolving legal backdrop, sometimes certain complaints can warrant investigation when maybe a few years ago they wouldn't have. So if you've got a complaint nowadays and it relates to potential sexual harassment, that might be at the top of your list or getting towards the top of your list of complaints that would warrant a formal investigation.
Yeah, absolutely. And there's probably a couple of things we should also add. So one, the question about when to investigate or what level of detail you need to take in terms of a process. I've said there's no kind of one rule, and there's all these other laws that you need to be mindful of. But the other thing you need to be mindful of course, is the relevant policies and procedures or the enterprise agreement and those rules that you have in your particular workplace. So if you've got a policy that says, if a grievance is lodged or if a complaint is made, we will deal with it in this way, then if you fail to do that, that might have some repercussion in an unfair dismissal matter where the Fair Work Commission, for example, is going to say, well, hang on, your policy says you're going to deal with it in this way and you haven't done it. So you also need to kind of view the steps that you take through the lens of what do the applicable policies and procedures say about that. I forgot my other point, Sam, but I might come back to that when it comes to me.
Now might be a good time to talk about the reluctant complainant. This is a scenario that often comes up. We often get questions from our clients about someone who's come forward with a concern or a grievance or a complaint. They've provided information about that concern, but then they go on to say, but look, I don't want you to do anything. What's your view on the right steps to take there, Kyle?
Yeah, so I've seen plenty of clients who have this kind of binary approach of, you can make an informal complaint and you go down this pathway, or you can make a formal complaint and we go down this pathway. Now, there's nothing kind of inherently problematic about that, but I think you want to maintain a level of flexibility to deal with things in a proportionate way. So there's no kind of one size fits all. In relation to the reluctant complainant, this does come up quite often. And there seems to be a view out there that if the complainant is not prepared to formalise their complaint, then the employer either cannot do anything about it or does not have to do anything about it. And my view, at least, is both of those things is wrong. Both those things are wrong. My view is if a complaint comes across your desk or you become aware of a concern or a grievance or a complaint, now that you are aware of it, it's almost secondary whether or not the complainant wishes to pursue it or doesn't want to be involved. The reality is you're now aware of a potential issue. If you do nothing, I'd have some concern that you might be in breach of your work health safety obligations. Like, let's try and give an example. Someone comes to you as a manager and says, oh, look, person X is bullying me. And you have a conversation with them and then they say, oh, look, you explain the pathway forward in terms of the policy. And the person then says, oh, look, I wanted to tell someone, but I don't want you to do anything about it. The difficulty for the manager in that scenario is you've now been told that there's a potential issue in your workplace. If you do nothing, that's not going to look great in 2 years' time when it becomes apparent that you were told about it, you did nothing, and the situation continued or got worse. So you have to manage the expectations of the complainant. And the conversation might be something like, okay, I hear what you're saying and I appreciate that this is the way that you want it dealt with or you don't want us to deal with it. The reality is we're now aware of it. We have obligations under work health safety laws and bullying laws and sexual harassment laws and lots of other laws to ensure that we take measures to make sure that this is a safe workplace. We can't do nothing about it. So we will try and manage and balance your desire in terms of how we handle it against our legal obligations and try and chart a path forward, which might be, the complainant doesn't have a lot of involvement in the investigation process, or the complainant might want to remain anonymous. You need to ultimately look into it. It's hard to give kind of one-size-fits-all guidance there because it's obviously going to be quite situation dependent. But what I think you should do, the biggest tip is managing the expectations of the complainant and not over-promising. So it might be to say, look, you wish to remain anonymous or you wish to not pursue it. We will do what we can within reason to give effect to your preferences, but ultimately we can't give you any guarantee that your identity is going to remain anonymous. For example, it might end up in court down the track, like it might be a 2% chance, but it might end up in court. There might be discovery, there might be subpoenas, there might be orders to produce documents. And you don't want to be sitting there as the HR manager going, I've promised that person that they will never be discovered, because ultimately you're probably not in that position to give that promise. So you just have to do the best you can in the circumstances, but you can't simply do nothing.
Indeed. And a related issue to the reluctant complainant is what we've got up here is the anonymous witness. So someone who maybe is approached by the investigator to provide information that might assist the investigation and says that, look, I'm happy to provide that information on the condition that I remain anonymous. Again, the task for the investigator is to really manage expectations from the get-go because, as Cahill said, there is an obligation, if you like, on the employer to look into these things and to conduct the investigation as thoroughly as possible. So it may be, and we can talk about this later when we talk about the golden rule, it may be that there can be some anonymity provided to a witness, but it would be a mistake to promise full anonymity to that witness.
Yeah, I totally agree. And I think we can touch on that in a bit more detail when we talk about the golden rule and procedural fairness. The other thing I just want to add in, Sam, before we move on to the next mistake is reluctant people. So quite often someone, whether it's a complainant or a witness or even a respondent, all respondents are reluctant because it's not comfortable to have allegations made against them. But in respect of reluctant people, employers typically have this implied right to issue reasonable and lawful directions to people. Now, sometimes you don't need an implied right because it might be an explicit or express right. So you might have something in a contract of employment or in an enterprise agreement, for example, requiring people to participate. But even if you don't, as an employer, you've got the right to direct people to participate in certain processes. As long as that direction is lawful and reasonable, employees must comply with reasonable and lawful directions. So just bear in mind that if someone says, oh, look, I don't want to be involved, the answer might be, okay, Barry, I hear that you don't want to be, but you're going to have to be. And we're going to direct you to participate because it's important. And so employers have that right, but equally, I don't think you should overuse it. You just consider whether or not it's necessary or appropriate in the circumstances.
Indeed, indeed. So we might move on to our next issue. Just checking for any questions. Looks like we're yet to receive one at the moment, so feel free to send them in if you can. The next mistake in our top 5 is choosing the wrong investigator. Now, this is a really, if this mistake is made and you have the wrong person looking into a complaint, it really can contaminate the entire investigation and the outcome of the investigation. So this is a really important thing to get right at the beginning. We've got a few points here on this slide. I think you could probably sum it up if you wanted to, as if you wanted to condense these issues down into 2 things. One would be that the investigator needs to be competent, so they need to be able to investigate the complaint thoroughly and effectively. They also need to be impartial, so they cannot have been involved in the incident They cannot have skin in the game, as they say. They need to be someone who's going to look at this without any bias, and more so without even the perception of bias. So in terms of capability, we've broken it down into two there. Kyle, did you want to run us through maybe the different types of capability that you would need to look for in an investigator?
Yeah, happy to do that, Sam. And like totally agree, you've nailed it. There's two things. You've got to be competent and you've got to be impartial. If you and really, so long as those two things are established, there should be no issue with that person investigating. So if you want to kind of simplify it as much as you can, as long as there's no conflict or the person's not involved in the subject matter that they're investigating, that obviously you can't investigate yourself. As long as there's impartiality, so i.e. no actual or perceived conflict, and the person knows how to do a decent job at investigating a particular issue, that's all you need. The slide probably, and I mean the first element of that slide is a die in the ditch issue as far as I'm concerned. You can't be involved in the incident. So you can't be a witness and you can't be the complainant or the respondent. The others are kind of considerations rather than hard and fast rules. So, investigative capability, that's the competent thing. So I misspoke. That's obviously one of the requirements. The subject matter capability is kind of a nice to have, but it's not essential. But this is a consideration when you're identifying who should investigate. So generally speaking, if something is a fairly typical HR grievance around bullying or sexual harassment, then I would expect most HR managers, HR business partners, operational managers would likely have the capability to do that. But from time to time, you see allegations that are more complex. So, you might have some concern about the CFO embezzling money or some kind of fraud. In those cases, you might want to look at an investigator who has some accounting or financial literacy so that they can properly understand the subject matter. More and more these days, you see things that involve IT systems, so breaches of confidentiality, and there might be some kind of complex IT evidence around the particular allegation. So someone, not ideal if someone doesn't know how to turn on a computer or use a computer to be investigating something that they just can't quite understand. So subject matter capability, you want to turn your mind to that. Then capacity is also a really important kind of logistical or pragmatic step or factor. If someone is so busy with their day job that they just don't have the time to do this properly, then obviously you should you kind of have to expect that if they're run off their feet, maybe there's going to be some compromises in terms of the quality and the timeliness of that. So you want to find someone who's actually got the time to do a proper job. And the timing is important with these things. The longer an investigation takes, the more stress, anxiety that it causes to those people involved. Often people, sometimes at least, I probably shouldn't say often, but sometimes people might be away from the workplace, so they might be suspended pending the outcome of the investigation. So you want to move things along, both, that's in the interest of the business or the employer legally, but it's also in the interest of the welfare and well-being of those people participating in the process. Optics, I think we've talked about conflicts of interest. So you might have scenarios where you're satisfied that there's no conflict, but it still just doesn't look right for a particular person to investigate the other person. I've seen it plenty of times where someone, it might be the HR general manager, who is competent, who is impartial, but who the allegation might have been made against one of their peers, so someone at the same level as them. And so they kind of say, well, look, I can do it, but I don't want to put myself in that awkward situation where I'm investigating a colleague. More likely than not, there's going to be some damage to our professional relationship, and that's not going to be a good thing. So you want to consider those factors. And again, optics from a proportionate perspective. So if an allegation is made against the CEO and the allegation might involve conduct that could warrant dismissal, you might not want the most junior, the most inexperienced HR person in the business undertaking that investigation. You might need someone more senior, and equally it applies in reverse. And then lastly, Sam, privilege. So legal professional privilege. Privilege is a complex legal issue, even for lawyers. But just bear in mind that if you internally investigate a matter, more likely than not, the documents that are produced as part of that investigation, so emails back and forth, will not be privileged, and so might be capable or might be required to be produced if there's litigation. Contrast that with engaging a law firm who might either do the investigation themselves or might refer and engage someone, a third party, to do the investigation. Where that occurs and the dominant purpose of the investigation or of the relevant documents is so that the law firm can give advice to the client, to the business, then there's an argument, at least. I don't want to say it's absolutely going to be privileged, but you can establish legal professional privilege, which then means documents might not need to be produced if there's litigation. So it's really complex privilege. You don't want to assume that all these docs are going to be privileged if it turns out that they're not. But equally, if the subject matter is particularly sensitive, might have reputational repercussions for the employer or for the organisation, you might just want to consider, is this something that we might want to be privileged? And if so, from the get-go, you need to establish that. So you need to speak to your legal advisor so that the investigation can be privileged.
Indeed. And Kyle, we've got a few questions coming in. The first one here, this might be taking a step back to our previous topic, but we mentioned that there's this notion that a lot of employers have about a formal versus an informal investigation. What are your thoughts on whether those categories have the right name and what might be the difference between those two?
Yeah, I mean, it's a fascinating, very broad question, which we could probably spend an hour talking about because, and so I'll try and simplify what I want to say. An investigation, in broad terms, requires an allegation or an issue to be put to the person. They need to have the opportunity to respond and provide their version of events. The investigator then will weigh up the evidence and might go and gather further evidence by speaking to witnesses or looking at CCTV or reviewing documents. Once you've gathered that evidence, you then weigh up the evidence and you make a finding based on the balance of probabilities, which is the civil standard of proof. You then effectively say, okay, well, this allegation is either substantiated or not. If it's not substantiated, you likely communicate the outcome and move on. If it is substantiated, you then turn your mind to, okay, having regard to the established conduct, so what we've found to have occurred, what, if any, disciplinary action needs to be taken? So, I mean, that in 60 seconds is what you're doing in an investigation process. How you do it is the kind of million-dollar question. Do you do it informally? Do you do it formally? As I said, it should be proportionate to the seriousness of it. But to give you maybe two examples of the two extremes, and then that might be helpful guidance for people. Someone makes a pretty low-level complaint. It's a grievance. You might go, okay, I've heard what you've said, so I've got the information from the complainant. You go and speak to you go and speak to the respondent. So you go and speak to Barry, and you say, look, this has come up. Barry provides his response and says, oh, yeah, look, I was frustrated and I snapped or whatever. Or, no, that's rubbish. That never happened. I wasn't even there. You might then speak to some other colleagues to try and work out, hey, did you see the little, Barney that these two guys had in the factory? And you gather some evidence. You form your view in your mind. You might not even write it down. You might just go, yeah, that's what happened based on the evidence. And then you might go and speak to the person and say, look, I'm satisfied that you did act inappropriately. Don't do it again. You might document it, you might not. Like that, that is effectively an investigation, going through those steps of finding out the information, putting the allegation, hearing the person's response, weighing up the evidence, making a conclusion in your mind, and then rolling out the implementation of whatever it needs to be implemented. So you could do that potentially in 15 minutes. You might not create any document at all. Now, that's obviously a really extreme informal process that in many cases might not be sufficient. Now, you then go to the other extreme, and Sam, you and I, do a lot of these, where we're engaged to undertake a formal external investigation. We write letters to people telling them that a complaint's been made, and we outline the process. We write letters particularising the allegations. We give them 48 hours notice or whatever of a meeting. We then require them to attend an interview with us, which might be in person, might be virtually. We might record that interview. We might take a transcript. We might take a statement. We might do that for all of the relevant people we need to speak to. We might then write a 70-page investigation report. And that might take 6 weeks. And then the employer will roll out whatever outcome. So formal, informal, look, as I said, you have to kind of have a reasonable process based on the seriousness. Anywhere between those two spectrums is okay, so long as it's proportionate. And this is a nice little segue, Sam, into the golden rule, which is the next issue. And I'm conscious of time, so we might move on to that.
Yes, indeed. So we touched on this before. Essentially, we're talking about procedural fairness. The idea of procedural fairness is that if an allegation has been made against you, you should have a reasonable opportunity to understand what the allegation is and an opportunity to respond to that allegation. So if we break down what that means in the context of an investigation, often we see, if we're talking about mistakes made during an investigation, often the classic mistake is that not enough detail was provided to the respondent. Kyle, what are your thoughts on the level of detail that needs to be provided?
Yeah, so I think I was going to say the more the better, but there is actually a limit on that. So don't take that too literally, that the more the better. What I say you want to do is provide as much detail as you can so that the person properly understands what has been alleged. So that is, I come back to the kind of what, when, who, not so much why, but how. So in an ideal world, I would want an allegation to say, on or about X date, it is alleged that you engaged in blah conduct. You might specify a location, you might specify a time, and you might even specify, if it's, it's alleged that you said words to the effect of, and actually quote what the alleged comment was. So you want to be quite kind of forensic in your allegation. I have concerns with vague allegations, and we see it all the time. Allegations like, it's alleged that you bullied Karen. Like that in my view is just not good enough, because bullying is a label, or it's a characterization of a certain set of facts. So it tells me nothing about what it's actually alleged that I've done. So what I would like to see there is, it is alleged that you bullied Karen by engaging in the following conduct: A, ignoring her; B, not including her in certain things; C, and because they are the actual facts or alleged facts that then allow you to put the label, or allows the complainant to put the label of bullying on that course of conduct. So I think you need to kind of try and be as forensic and legalistic, not so much legalistic, but come from the approach of what, when, how, why, etc. Once you've done that, the person should have sufficient information to provide their response. My view, and Sam, we had a chat about this morning, my view is people don't necessarily need to know who's made the complaint against them. I always come from the perspective of procedural fairness requires them to have sufficient information to understand what the allegations are so that they have a reasonable opportunity to respond. So my default position is, well, it's been alleged that you have done X. You either have or you haven't. You now know what the allegation is, so you should be able to tell me whether you did it or not. Who has made that complaint or who has brought it to my attention is kind of neither here nor there. And I should qualify that slightly, Sam, by saying there might be some occasions where the identity of the complainant or the identity of the witness is important, and if you don't provide it, it leads to a denial of procedural fairness. But the default position is you don't necessarily need to tell them who the complaint's been made by.
And we often see respondents in investigations taking this concept of procedural fairness and really running with it. So you may get a request from a respondent where they want the names of all the witnesses, a transcript of all of your conversations with witnesses. They even may want a copy of your investigation report when it's finished. Is that taking it too far? Is that something you can just simply say no to?
Yeah, so I think generally speaking, the answer is no. You can say no to that with this qualifier. If you have a recording of the interview with them, or you have a transcript, or you have taken notes, then perhaps, and I think particularly in audio recording, be mindful. There's workplace surveillance, and there's particular legislation which varies from state to state and territory. But you might need the person's consent to audio record a meeting with them. So bear that in mind. If you do that, then my view is they should be entitled to have the audio recording or at least a transcript so that they can correct the record if they want to. But certainly beyond that, my view is they're not entitled. And the kind of golden rule of procedural fairness does not extend to meaning that they have some entitlement to get the notes or the transcript of what everyone else in that process has said about them. I think the answer is no, and that might breach the confidentiality of other people. Or the reality is, if you did that, then come next time you have an investigation, those people aren't going to want to participate because they're telling you some stuff in confidence. So, and then if we turn to the investigation report, Sam, they're entitled to know what the outcome is and some reasoning as to how you reach that conclusion or outcome. But generally speaking, unless there's some EA right for them to get a copy of the report, the answer is no. You shouldn't be giving them a copy of the investigation report. At best, you might provide them with an extract or something like that.
Yes, indeed. And another thing that often comes up in this, sort of under this heading, would be this question of not rushing to get to notify a respondent of a complaint and not rushing to put allegations to the respondent. We don't want to rush because that may lead to missing out on certain facts that should be put to the respondent. But at the same time, we don't want an undue delay in notifying the respondent and putting allegations to the respondent. The main reason for that is that we don't want the respondent sitting there scratching his head wondering what's going on with the investigation. That tends to just sort of raise the level of anxiety that's normally associated with investigations.
Yeah, and so I think we get asked a lot about the sequence of events or the process that should be adopted. And again, there's no hard and fast rules. There's no one-size-fits-all approach. But typically speaking, you receive a complaint. It might be written. It might be verbal. Generally, you might sit down with the complainant and get a little bit more detail about them. So you might do that in a meeting. It might take an hour. And what you're trying to do in that meeting is to understand what the concerns are with as much detail as you can. My preference is to ask the complainant, if they're willing to put the complaint in writing, because I always find that focuses the mind on some people verbally kind of just talk in circles and they talk in generalities. And as investigators, what you want to know is, well, hang on, precisely what are you complaining about? What is it? What did that person do? So step number one is just trying to understand what the issue is. You might then notify the respondent, put the allegations to them, and set up a time to meet with the respondent. You could do that. And then thereafter, you might speak with witnesses. But equally, after meeting with the complainant, you might choose to speak to the witnesses first before putting the issues to the respondent. And it's just, look, to be honest, it's a bit of a gut feel as to how best to do it. Quite often what happens is the complainant will say, oh, look, this person has engaged in similar conduct towards person A, B, and C. And so in that case, I would say, well, look, go and speak to A, B, and C first before you speak to the respondent, because more allegations might come out. You might go from having one complainant to 4 complainants, or you might go from having 3 allegations to 10 allegations. So that would seem to make sense in that setting to speak to witnesses first. But equally, it might be you're very clear on what the issue is. It's a discrete issue. You speak to the respondent next, get their version of events, and then thereafter speak to witnesses. What you're trying to do in terms of the sequence of events is trying to avoid having to go back and speak to someone for a second time as much as possible. It's never perfect. And for example, if you speak to the witnesses before the respondent, and then you speak to the respondent, and the respondent raises stuff that you're hearing for the first time, you then might need to go, oh, well, hang on. I now need to go back and speak to those witnesses to say, well, actually, it's been suggested that this happened. What do you have to say about that? So it's all a little bit iterative as to precisely who you speak to, but it typically is complainant first, either witnesses and then respondent, or respondent then witnesses. And I've forgotten your question. Sorry, that was probably a very long, rambling answer to your question, Sam.
No, I think you've answered it. It's about finding that balance, and sometimes it is about gut feel. Like, when do we notify a respondent? When can we put these? Do we have enough detail to go ahead and put allegations? Do we need to do some more digging? Or maybe we can put allegations now and then do some more work afterwards.
Yeah, and yes, thanks. You've prompted me. In terms of advising the respondent, I think give some thought to that. That shouldn't be something that you just run off and do without proper thought. I've seen scenarios where the respondent is advised that a complaint has been made against them, and the natural response, anyone in that situation would say, well, what's the complaint? What is it alleged that I've done? If you then say to the person, oh, look, we're still looking into it, we're not sure, we'll come back to you in 2 weeks' time. That, in my view, is not optimal and far from optimal, because that person is then suddenly on notice that a complaint's been made. They don't know what it is for 2 weeks. Equally, you don't want to advise them of the allegations and then say, oh, but hang on, I'm speaking to 4 witnesses next week, so I won't be able to speak to you until the week after. So you just, you have to appreciate that these are very stressful situations for everyone involved. And so give some thought to when you notify them. Don't notify the respondent until you think you can turn around the particulars of the misconduct pretty quickly after telling them. And then on the flip side of that is I've seen it arise where a complaint's made, you interview the complainant, you interview 10 different witnesses, and you try to get all your ducks in a row to understand precisely what's happened before you advise the respondent, because you don't want to stress them longer than you have to. So for precisely the reason I just said. But the risk of doing that is if one of the witnesses breaches confidentiality and tells the respondent, well, the respondent finds out that there's this investigation into them, and the investigation's been going for 2 weeks, and they had no idea that there was any issue whatsoever. That naturally, the person's then going to say, well, hang on, what's this witch hunt that's going on about me that I have had no knowledge of whatsoever? So you need to kind of try and balance that. And from the time you advise them that there's an issue, you want to try and you want to try and compress the time from the day you tell them that there's an issue to the day you give them the right of reply, because that's the really key stressful moment for the respondent.
That's a very good point. Jumping forward in time now, let's assume the investigation has been concluded and the report is to be written. One of the mistakes that we see is a report that just doesn't include enough detail. And when we say detail, we're really talking about the reasoning that led to the findings. Cahill, when you look at an investigation report, what do you want to see in there?
So most reports should typically follow a fairly similar structure, in the sense that what you want to see in the report is, one, what are the allegations? Two, what is the evidence? And you might focus a little bit more on what the respondent has said, because they're the person who really needs to be given the procedural fairness, because they're the person at risk of adverse findings. So you want, what's the complaint? What is the information? So what is the evidence, the relevant evidence that I have gathered in looking into this issue? You then, of course, need your findings. So that is point 3, the conclusion. What have you actually concluded? Is the allegation substantiated or not, based on the evidence? And then the 4th point, I think, is why have you made that conclusion? And in my experience, the reports that I've read from clients doing things internally or externally, most people, I think forming the allegations is a bit of an art. And I've already said you want to give as much detail as you can. They want to be specific and kind of forensic and factual based. So that can be tricky, but people are pretty good at summarising the information they've gathered. People are pretty good at kind of intuitively knowing who should I speak to, the people involved. People are pretty good at asking questions and gathering that info. And I think people are pretty good as well at intuitively forming a conclusion in their mind as to whether or not the allegation should be substantiated. Where I see often the shortcomings is in articulating why you've landed on that conclusion. To give you an example, I saw one, this was a little while ago now, but I saw a report that said, this was the allegation. Person A said this occurred. Person B said, no, that's not what occurred, and in fact, this actually occurred. Conclusion is allegation substantiated. And so inherent in that finding is that the investigator has preferred person A's version of events over person B. But I have no idea why. I have no idea whether there's any other evidence that might support that. So I think the critical piece, without kind of sounding like I'm lecturing too much, is if you've made a finding, explain why. So it might be that person's version of it, it might be that the complaint was admitted. It might be that the complaint was denied, but there was a corroborating witness. So a witness who said, yes, I saw it, and that is what happened. So you've got corroborative evidence. You might have documentary evidence that supports the allegation. You might have other, like CCTV or other things. You might have an allegation that has a ring of truth to it. You might have a complainant who is candid, credible, has no vested interest in making the allegation, and you might have a respondent whose explanation just is quite odd and doesn't sound like it's right. So, and then you might have credibility issues as well. So all of these things are factors that you might rely on in reaching a conclusion. And if you do rely on those, you should articulate that in the report. So the investigation reports that we do, Sam, are very clear. This is the finding and this is why. And because the why is really critical, because if there's an unfair dismissal or some litigation and the report's produced as evidence and the Fair Work Commission or some judge is looking at it, they're going to be looking pretty closely at why you reached the conclusion you did to try and work out whether it stacks up.
Indeed. And there's just a couple of technical points on the slide there about the standard of proof. In workplace investigations, we're often dealing with what is called the civil standard of proof, or the balance of probabilities. And so that's something that when the investigator is making findings, the investigator should probably have that standard in mind, essentially thinking, well, what version of events is more likely to have occurred? Another one is, if you're making a finding about whether a certain type of conduct has occurred, for example, it may be sexual harassment, it may be workplace bullying, we need to look at defining that type of conduct with precision. And so that may be that you're drawing upon a definition found in the organization's policies. It may be that that type of conduct is defined in some legislation. So for example, workplace bullying, sexual harassment, they have their own legal definitions. And so if we're trying to make findings about whether or not someone has engaged in that type of conduct, we need to be using those correct definitions. We've got one more topic, and we'll try and get it in. We are running out of time, but this last topic is about this kind of merger between investigation and decision, or sort of disciplinary action. As an investigation purist, we always recommend that you try to distinguish and separate those two things. And we've got some points here. Kyle, why is it good to have an investigator that is solely an investigator?
Yeah, so I think the separation is that the benefit of the separation is the investigator can investigate the allegations and make findings of fact based on the evidence. And they then are not the decision maker in respect of disciplinary action or sanction. We have someone separate in an ideal world. And look, I'll be frank, you don't need to have this separation. It's not fatal if you don't have the separation, but certainly the preference is if you can have an investigator who is a different person to the person who is the ultimate decision maker. What it means is if there are shortcomings in the investigation, it won't necessarily taint or invalidate the decision maker's decision or the sanction or the disciplinary action that's been imposed. So we can kind of have that degree of separation. And equally, I think as well, there's a real benefit in a decision maker who hasn't had to get down to the level of nitty gritty, down in the weeds, looking at every little skerrick of evidence, but coming in at the end of the process and saying, okay, what are the findings? Do I agree with those findings? So sanity checking the evidence and going, yes, okay, I understand why those findings have been made. I agree with them. I'm going to effectively endorse those findings and communicate the outcome. And then I'm going to be the person who deals with the sanction. So that is what disciplinary action should be taken. You're coming in with that kind of fresh set of eyes rather than potentially having kind of gone through all of the detail and all of the evidence. I think sometimes when you get down to that level of detail, it can naturally be difficult to kind of be as objective as someone else might be who can kind of come in and not have had to sit through 22 meetings or something like that. So I think it's helpful, but again, I don't think it's not fatal. And small businesses that might have 10 employees and you're the owner of that business, you might not have the luxury of having someone separate, being the investigator and the decision maker. You might wear both caps. That's okay. But in an ideal world, if you can have two separate people, our preference is that you should do that for those reasons. Fantastic.
And we had time set aside for questions. It looks like we have run out of time, unfortunately. I did my best to try and fit in responses as we went, but we might have to wrap it up and leave it there. Just before we go, we mentioned before that we often conduct investigations on behalf of our clients, so an external formal investigation. Here's a list of some other ways we help our clients. One of the new things to note on there is the how-to guide for discharging the new positive duty. That's in relation to sexual harassment. So please email the address on that slide if you have any questions about any of those services, or if you have any follow-up questions or you want to discuss anything that we talked about today. But we will sign off there and wish you a happy afternoon. Thank you.